if Section 203 applied to Hillary the movie, just understand the blackout period for the presidential election began in about December of 2007, because when she was running in the primary, she was a candidate somewhere for about 7 months. So they couldn't really advertise their movie because somebody in Iowa might, click on, and that, of course, that would be prohibited. So it was an interesting experience to the oral argument in March, because here what you had was an as-applied challenge. Because remember, those of us who hate McCain-Feingold had already lost back in 2003 when we said there are no circumstances where this can possibly be constitutional. So we lost. But then the court said, well, as applied to the facts in Wisconsin right to life, well, maybe. So, it's unconstitutional there. So now then, you had Ted Olson arguing for the petitioners who had argued on the other side in the McConnell case. Interesting. But arguing a fine line between whether or not this whole statute should fail, which it should, and arguing, but as applied to Hillary the movie, as applied to these ads, it cannot possibly be constitutional. What's really interesting is that it really gave, though, for the first time, a real insight, I think, to the statute and the tangled web when you start messing around with what George Will calls the 5 most beautiful words in the English language: Congress shall make no law. And actually that began to be the justices in the March oral argument really got above and beyond some of the spaghetti of the tangled web of BICRA and said, well, gosh, if you can, is video on demand even covered? Justice Alito said, well, let's see those Kindles. When you have a Kindle, is that a satellite transmission? So if you were reading a book on a Kindle, is that covered? And then they said, well, gosh, could you, and ask Malcolm Stewart, the Deputy Solicitor General, who I have to tell you, I believe is the last honest man in Washington. Because they asked him, and he answered truthfully, well, does that mean that a corporation couldn't publish a book if it said vote against or vote for a candidate? And he said, yes, that is correct. The government could say that. And then the court is, oh my gosh, a book. And then they and then they ask him, and he very honestly said, well, this court this isn't new. This court said that a citizens group couldn't publish a newsletter. But that was back in the Massachusetts Citizens for Life case back in 1986. They said that was a corporate contribution illegal under the FEC, under FECA. And they only carved out an exception because they said, well, this particular kind of corporation ought to be able to do this newsletter. But he was trying to say, this is not new. This is what the law says. Well, I think the court said, we really need to rethink this. And so they asked the parties to rebrief and re-argue 2 questions. Should we reverse our decision in McConnell on the facial validity of Section 203? And should we reverse our decision in Austin versus Michigan's Chamber of Commerce, which was a case decided in the 1980s in which a state law, a Michigan state law, that prohibits independent candidate-related expenditures by a corporation using its corporate treasury funds. And that was what the argument was. That was the question. And it really honestly freed the petitioners, Citizens United, to come forward and not be shackled with this as-applied thing, and to be able to say, you should reverse yourselves because this is a mess. And we're going to keep coming back until you get rid of this, because it's going to be one as-applied challenge after another, and each one makes it more difficult to understand what the law really is. I must say that Elena Kagan didn't really cover herself with glory, in my view, because she wanted to try to undo the damage Malcolm Stewart had caused by telling the truth. When they asked him, could this apply to a book? And he said yes. And she said, Section 203 could never be applied to a book. Well, of course, not applies to radio, applies to satellite, cable, and network broadcasting. But she then went on to say that the FEC had never tried to punish anyone because of a book. And I actually want her to go back and read some of the cases, because I can tell her some of the ways that the FEC has gone after things like newspaper columns, magazine columns, the George Soros book, when he was traveling around the country to promote his book in 2004 against George Bush, and that's actually a controversy pending at the FEC at the moment. But it's going to be a very interesting thing to see what the court does. Frankly, Justice Kennedy is always the surprise, but he was a dissent in the Austin case. And so I think that we may see 5 votes for overturning both McConnell and Austin. The grounds on which they do it, how wide-reaching it is, far-reaching, we don't know yet. But that's pretty interesting, and I think it's going to be particularly interesting because there are 2 more cases that are coming up. One which could come up this term, which was decided a couple of weeks ago, involving Emily's List, which is a liberal organization, a PAC, but they have non-federal account. The FEC regulations had said that they had to all dollars that they spent had to be federal hard dollars, even if they were only talking about state candidates. And the decision by the special 3-judge panel was very far-reaching, saying we cannot constitutionally limit speech and communications by citizens groups if it's done independently of a candidate. So that's going to be coming to the court probably this term, would be my bet, because it is an expedited and mandatory review. Now let me turn to my other case that I'm supposed to talk about. Now, do I have time? Quickly. Okay, I'm supposed to talk about Conrad Black versus U.S. Now, this is a case involving honest services fraud and whether or not the statute is constitutional. I'm going to just very quickly tell you, this is a case where Conrad Black was indicted for, and he and others were indicted for fraud because they had received certain payments from the sale of assets of Hollinger Company. I'm going to mess up all these facts. I'm trying to hurry. But they characterized those as they characterize those as non-compete payments subject to a non-competition agreement in order to receive favorable tax treatment in Canada. The government said that was in addition to indicting them on fraud, that they also indicted them on honest services fraud under Section 1346 of the Criminal Code by basically saying that they owed a duty to tell their Hollinger that they were getting this money, etc. Well, without getting into all the things, I guess the important point here is Justice Scalia has been on something of a tear that this section of the statute, which was invalidated 20 years ago, but then Congress made a change, basically says that, I'll just tell you what Justice Scalia says, that without some coherent limiting principle to define what the intangible right of honest services is, whence it derives, and how it is violated, this expansive phrase invites abuse by headline-grabbing prosecutors in pursuit of local officials, state legislators, and corporate CEOs who engage in any manner of unappealing or ethically questionable conduct. Essentially what we have in all of these, the reason this is important in my area of work is that the Kevin Ring trial that's ongoing right now is largely based on this theory of honest services fraud. The people who, a lot of the Jack Abramoff and the people who have pled guilty and been charged in relationship to lobbying and gifts and all, the honest services fraud has been the primary charge, because there has not been a quid pro quo established in any of those cases or even charged. It is painting a picture of giving tickets to events and then having staff members or members writing to their colleagues, getting earmarks, that kind of thing. There's no evidence of the linking, you give me this ticket and I will get you this earmark. It's the grooming. In fact, the indictment includes grooming. Walter may want to talk about the Jeffrey Skilling amicus brief, because there are really 4 different theories being advanced, arguments being advanced to the court, and who knows what the court will decide.